Hey, everybody. Welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Zach, the dog, I guess, as you so eloquently put it, has finished licking the whipped cream off my butt. So here I am. What the hell are you talking about? Good morning, by the way. Um, so we're going to do a quick recap of last night's filing. I'm trying to do faster streams for those who don't like to sit and listen to me talk for hours on end. And so I'm going to get right into it. It's going to look like I have a lot of these pages highlighted in full, but they're not all like that. And there's not very many pages, so no worries here. It was a really good filing. There was lots of good stuff in it. It wasn't like personally attacking anybody, but it had like a little bit of sass to it, I felt like, and the conclusion was actually really hilarious. So we're going to go ahead and take a look at this now. Okay. Lively's response does not attempt to show personal jurisdiction over Wallace or Street under New York's long-arm statute, but rather her theory of personal jurisdiction, a conspiracy-based theory. Okay, response at 2 is the sole jurisdictional issue, which is whether the Wallace parties were members of a conspiracy. Response at 12. Thus, Lively argues personal jurisdiction is not based on the Wallace party's own acts in New York. There are none. But rather the acts of others, the co-defendants, under the doctrine of conspiracy jurisdiction, a gloss on personal jurisdiction, where defendants can be subject to personal jurisdiction because a co-conspirator's minimum contacts are imputed to the otherwise remote defendant. Okay. Furthermore, conspiracy jurisdiction has been rejected by the Texas Supreme Court in National Industry Sand Association versus Gibson and the United States Court of Appeals for the Fifth Circuit, which includes Texas, where the Wallace parties reside, thus informing due process fairness, which the response never even discusses. Here, Lively's only allegations regarding conspiracy jurisdictions are made on information and belief, argumentative inferences, and legal conclusions couched as factual allegations, which this court need not credit. Lively claims wrongly under settled and binding authority that this court should ignore the Wallace Declaration. But even if the court does not credit the Wallace affidavit, although it must, plaintiff bears the burden of establishing conspiracy jurisdiction and yet does not allege 1, when or where the conspiracy was formed, 2, who was in it at what point in time, 3, what acts the alleged co-conspirators performed in New York, 4, how the conspiracy was aimed at or directed at New York, especially when the complaint does not allege any territorial boundaries for the sophisticated and well-funded retaliation campaign that sought to bury and destroy anyone, not just New Yorkers, that challenged his, Baldoni's, brand. 5, when the Wallace parties joined the alleged conspiracy, apparently it was later. 6, and what they what they specially did to further the aims of the conspiracy in New York. And 7, Wallace's awareness of those acts taken by the alleged co-conspirators and that those acts were in New York. Okay. For venue, Lively totally ignores that the plaintiff bears the burden of showing that venue is proper for each claim against each defendant. Lively instead lumps other defendants' alleged actions and attributes them to Wallace for venue. Next, Lively wrongly invokes the first filed rule where, as here, Wallace and Street were not sued in her initial complaint, and this court lacks jurisdiction over both. Finally, if the court reaches the merits, it should dismiss. For intentional infliction of emotional distress, to avoid Hustler, one of the cases that they cited, Lively argues that Wallace and Street did far more than publish statements, but her complaint says otherwise, and her own California cases support dismissal. For false light, either New York law or Texas law apply because Wallace's alleged conduct occurred in Texas, and the purported ultimate impact was felt by Lively in New York. And for FEHA, Lively's cites to the amended complaint do not add up to knowledge. Her California cases go against her, and she ignores that Wallace was not her employer. Okay. I might start skimming over some of this stuff, even though it's highlighted, because I'm trying to keep this under 15 minutes for those of you who ask for shorter form stuff. So if you want to hear me read through the whole thing, of course, I'll link in the description of this video after the stream to the stream from last night. It was only like 40 minutes. All right. Personal jurisdiction. While the response ignores Lively's previous sworn statement in her Texas litigation, this court should accept her judicial admission that that the critical evidence relevant to her claims, the specifics of the conduct by Mr. Wallace, is not otherwise available to her. Okay. To provide Lively in this court with those specifics, Wallace declared he took no overt acts to retaliate against Lively. Rather, Wallace merely observed social media passively and recommended that everyone should let the sentiment on social media unfold organically and not do anything. That's like the opposite of what she's saying he did. So were there a conspiracy to destroy Miss Lively and punish her? Wallace and Street were not an integral part, nor does the complaint allege as much, although the response belatedly claims the Wallace parties at some point in time became an integral part of the conspiracy. In advocating for personal jurisdiction, Lively never identifies any specific co-conspirator committing any specific act that qualifies under Section 302A2, an act taken while physically present in New York. Okay, and she's seeking to impute that to Wallace through the conspiracy theory jurisdiction. Okay. At most, Lively points to amended complaint paragraph 26, which characterizes Sarowitz's comment that he would spend $100 million to ruin the lives of Miss Lively and her family, which later really turned out to be a statement that he was prepared to spend whatever necessary to defend Baldoni, Wayfair Studios, and himself. So she mischaracterized that quite a bit, didn't she? But we already knew that, or assumed it, rather. But Lively never explains why this comment is tortious conduct in New York, or that Wallace was aware of it, let alone both. No other paragraph that Lively points to in the response for personal jurisdiction mentions New York, nor does any paragraph allege any awareness in general, or of any specific act in New York. For Wallace's participation in the conspiracy, Lively cites 2 paragraphs to support that TAG, the agency group, engaged Mr. Wallace in street relations to design and implement a social combat plan. The first paragraph are texts between Abel and Nathan that never mention Wallace or Street. The next paragraph is an allegation on information and belief. TAG engaged Mr. Jed Wallace around the same time to design and implement their social combat plan. First, this is exactly the type of conclusory allegation based only on information and belief that are not sufficient to provide factual support. Second, this court generally takes the allegations in the amended complaint as true, but only to the extent they are uncontroverted by the defendant's affidavits. Lively instead claims Wallace's declaration is irrelevant to the personal jurisdiction analysis by misciting inter alia Dorchester Financial Security Incorporation versus Banco. But the Dorchester court did not prohibit the trial courts considering materials outside the pleadings, as we have made clear that a district court may do so. One sec. Okay. And this page is like where it's like we're going to read pretty much the whole page. So this court can look to Wallace's declaration and see Lively does in fact lack the specifics of the conduct by Mr. Wallace, because her general allegations get his conduct all wrong. Wallace or Street did not post anything on social media on behalf of Wayfair or about Lively, Reynolds, the movie, or any of Lively or Reynolds' businesses. They didn't direct or ask anyone to post anything about the same. They didn't publish directly or indirectly any information or content, negative or otherwise, regarding Lively, and Wallace specifically forswears that a social combat or social manipulation plan is not a service he provided related to anything in this case. Third, even setting aside Wallace's declaration, paragraph 216 in Lively's complaint is merely an allegation that TAG hired Wallace to design and implement, not that Wallace actually did design or implement anything. It does not plausibly allege what overt acts he ended up taking. Namely, that he designed or did anything to implement a plan. Okay. Lively wants this court to draw an inference from her conclusory information and belief that Wallace was hired to do an amorphous retaliation campaign and that he then carried it out, but she never gets into specifics. Okay. Beyond those 2 paragraphs, Lively generally gestures to her background section. The allegations on page 6 describe Wallace and Street, but do not allege that Wallace did anything here. On page 7, Lively finally gets to what she supposes Wallace did: seeding, manipulating, and advancing disparaging content on social media platforms and internet chat forums. But this is just another way of saying Wallace and Street retaliated against her, a threadbare recital of her claims and a legal conclusion couched as a factual allegation. As for paragraphs 250 to 57, these are more vague references to a digital team, not Wallace or Street. Okay. She also bolds and italicizes other vagaries, like efforts to shift the narrative from some random tag employee who is not alleged to be part of the conspiracy. But bolding and italicizing her conclusory claims do not make them any more specific in the face of Wallace's declaration, explaining specifically that he did not post, like, boost, or ask anyone else to do so. Whatever Lively says about Tag, Nathan, or Abel, what she does not say is that Wallace made any particular post, liked or otherwise boosted any story or post, or really explain how Wallace joined in on the alleged conspiracy to destroy her. That is because if it happened, which Wallace cannot deny it did because he was not there, but again he doubts, it did not involve Wallace. As Wallace explained in detail, his recommendation was to do nothing on social media because Baldoni was already organically crushing it on Reddit, which, remember, is one of those text messages that they're using to say this is like damning evidence of a smear campaign, which is not even true. It's just like apparently observations he was making because he was watching social media trends, which is, what he was hired to do. So this paragraph, however, admittedly corroborates one allegation in Lively's amended complaint, where Lively posted charts showing online sentiment began to turn negative in July, 2 weeks before Lively alleges Wallace was hired. That's awesome. So they're saying basically admittedly, yes, this one part is true. It's the part where she shows that online sentiment turned against her in July, but it was 2 weeks before he even came onto the scene. So basically it was like, yeah, basically this one part of her complaint, it's true. It's the one where people started to not like her. But unfortunately, that had nothing to do with him. Lively's amended complaint stays at a high level because she lacks the specifics, but now that she has them in Wallace's declaration, she wants the court to disregard them. Plaintiff offers no reason to question Mr. Wallace's sworn statements or to believe that its requested discovery will yield a basis for this court's jurisdiction, other than to call it self-serving. Okay. This is where they go more into the legal arguments, which is something I'm sure a lot of the lawyers are going to go through. So, venue. For improper venue, she ignores that the plaintiff bears the burden of showing that venue is proper for each claim against each defendant. She never alleges or points to a single action that the Wallace parties took in New York. To support her conspiracy theory of venue, she ignores controlling authority from the United States Supreme Court, which holds that the acts of co-conspirators cannot be a basis for venue. Rather, venue must be established as to each defendant. The only thing Lively has said about where Wallace's actions took place was under oath in a Texas filing, where she swore a substantial part occurred in Hays County, Texas. Lively agrees with all these principles, as she has said in moving to dismiss Wallace's Texas complaint against her for lack of venue. Instead, in defamation actions, courts look to the defendant's conduct and where that conduct took place to determine where a substantial part of the events or omissions giving rise to the claim occurred. As to the first filed rule, Lively emphasizes that it does not require identical parties, but she cites cases where those attempting to evade the first filed rule were still involved in the first filed case. But Wallace and Street were not involved in this lawsuit until she named them 2 weeks after Wallace's lawsuit in Texas federal court. Finally, Lively cites that Wallace's Texas action includes anticipatory declaratory judgment relief and argues that it is not entitled to priority under the first filed rule. In any event, this special circumstances exception to the first filed rule does not apply because Wallace did not only bring an anticipatory declaratory judgment action, but also a substantive claim for relief for defamation. Failure to state a claim. So they're talking, Oh my God, they heard me coughing. The ambulances are coming. I don't know if you guys can hear that in the background, but I live near a hospital. So for IIED, intentional infliction of emotional distress, she cites AC paragraphs alleging that Wallace and Street published negative comments or elicited others to do so. Wallace denies making any such comments, but taking her allegations as true, the gravamen remains that Wallace's First Amendment activity of speech, even if that speech was not under Wallace's name. Hi, Lauren. I am 12 minutes late catching you, so I have backed the video up because your coverage is great. I don't want to miss it. Well, thank you, Sarah. I appreciate it. Oh my gosh, it's already been 15 minutes. We're going to speed through the rest of this. How about it? Okay. Lively's actual malice allegations that amount to one paragraph, that she has a threadbare recital of the elements of actual malice and the conduct and knowledge of people other than Wallace and Street. Okay. Lively does not allege any specific negative post about her business accounts, or her loved ones came from Wallace or Street. Lively's California cases also support dismissing her IIED claim, so the result would be the same. For false light, Lively never addresses that Wallace cites binding circuit precedent, explaining that New York choice of law considers where the plaintiff suffered the greatest injury, usually the plaintiff's domicile, and where the statements emanated were broadcast. That is either New York or Texas, neither of which recognize false light. Okay. For her FEHA aiding and abetting claim, Lively's own cases again make the case against her. Here, Lively's claim turns on retaliating against her for sexual harassment and HR complaints, but she never alleges that Wallace knew of any HR complaints or claims for sexual harassment that qualify as protected acts under FEHA. Lively merely mishmashes, and I remember seeing that last night and thinking of mashed potatoes, one allegations about Wallace with one about HR complaints with Nathan and Abel, without explaining how Wallace knew or claiming he did. And Lively's reference to paragraph 260 and alleged misconduct is not even misconduct alleged by Lively, so it cannot be the basis of her retaliation claim. She also totally fails to connect the allegations in paragraphs 261 to 66 to Wallace in any way. Like most of her response, Lively also just fails to respond. Lively has not even alleged Wallace's knowledge of any particular acts or protected action for retaliation adequately, but even if she had, it would not be enough. As Alk, and I don't know if I pronounced that right, says, the alleged aider and abetter must have known the employer's conduct violated FEHA. And here's the conclusion, which I think is the best part. Beyond being listed as parties, the Wallace parties are barely mentioned in Lively's 141-page, 482-paragraph, 5 attached exhibits amended complaint. If this were a Hollywood movie, the critics would deem the script overwritten and the peripheral characters, Wallace and Street, underdeveloped and therefore cut from the film. Of course, no one likes to be described as a bit player or an afterthought, but the Wallace parties will get over it because the lack of attention necessarily leads to the conclusion that there is no adequate factual predicate for this court's exercise of jurisdiction or venue, and the case as to them should be dismissed without prejudice. In the alternative, the claims against them should be severed and transferred to the U.S. District Court for the Western District of Texas, where a claim against Lively by the Wallace parties is pending. But if we are truly into almost happy endings, the court could reach the merits and, if it does, dismiss the claims against the Wallace parties with prejudice. We predict the Wallace parties and the critics would like that. A cleaner storyline and, sadly, for some, less attorney's fees. All right. Sorry, I went a little longer than I meant to, but hopefully, I got through this quick enough for you guys. We're expecting another response today from Blake's team, so I will be back most likely tonight. I don't know when they'll file that, but I'll keep an eye out. So thanks everyone for being here. Don't forget to hit the like on your way out, and I'll talk to you soon.